a civil union. And I think when you look at, when you're applying for benefits, let's say even Social Security for survivorship benefits, they're looking for the surviving spouse. Or if you're looking for VA benefits, they're looking for the surviving spouse. So I think to the extent that Windsor redefines marriage, its scope is limited to an actual marriage and not a civil union, which, as you pointed out, is a completely separate legal entity. And I think particularly now when we're just in the couple months following the decision, there's going to be a scrambling of sorts on the federal government's level to make sure that everyone that's applying gets what they need, because now all of the federal government benefits have been opened up to finally a larger group of people. So to the extent that they're looking at applications, they're looking at things such as, is this person a surviving spouse versus someone who's a party to a civil union?
Wow. So if a couple who's in a civil union state and gets a civil union, they come to Massachusetts, I guess the advice is to get married.
Absolutely,
Wow.
absolutely. And I guess my thought would be there's no downside to getting married. It simply makes everybody's rights more clear, and that flows into divorce. You know, that's always the big question with a civil union is, what do you do if it doesn't work out? In Massachusetts and the Northeast, folks whose marriages are recognized have the opportunity to go into the probate court and have everything dissolved. And there's important tax ramifications, like the deductibility of alimony payments that are being made, or the division of property, which all of a sudden, you know, thanks to Windsor, now that we have recognized legal gay and lesbian marriage, now we can make those transfers between spouses without there being any tax ramifications of it. You want to be able to take advantage of that. God forbid the union goes south. So getting married protects those rights. It also opens up the opportunity to pre-marriage planning for the prenuptial agreements, which is something that is, you know, you can't take availability of that, I don't believe, with a civil union, but you certainly can going into a marriage. You can sign a prenuptial agreement.
So just so I understand, from a couple getting divorced, and in a state that doesn't recognize marriage, there are federal tax consequences to the division of the union's assets.
Correct.
Whereas there wouldn't be if it was a marriage.
Correct.
Wow.
It really goes beyond, you know, when people think, well, this is great, now I can, you know, save on estate taxes. It actually goes so far beyond that. And that's, when you asked me earlier, what is part of your estate planning background and what do you do? Some of it is actually, I hate to say it, but preparing for the worst case scenario. And part of that is the prenuptial agreement before someone gets married.
What is it's a prenuptial before someone gets, what exactly is a prenuptial agreement?
A prenuptial agreement is, it's two people who are going to get married, preferably not on the eve of the wedding, that come forward, and that does happen occasionally, but they come forward and they disclose all of their assets and all of their liabilities to each other, and they agree that should the marriage dissolve, this is going to be how we're going to divide up the assets. A lot of people come in. It may be that the couple getting married, they themselves don't have any assets, but their family has significant wealth. So it's not so much that they're doing a prenuptial agreement to save their own current assets, but perhaps to protect an inheritance that's coming down the line. And most people will say, coming in, I want an agreement that says what I'm coming in with is what I leave with, if in fact it does not work out. And there's various modifications that you can do with that, including preparing for children and the protection of children and educational expenses and whatnot. But essentially what you're doing is you're trying to protect folks' assets from the ultimate dissolution.
Wow, so yes, another way gay and lesbian couples can
Absolutely.
protect themselves. So you do a prenup, I imagine it's full disclosure of all your assets and everything. Does each party need an attorney, or can they just go to one attorney and they? that
You-
attorney drafts everything.
You absolutely want separate attorneys. I get asked that question, I would say 9 times out of 10, because it's always, there's usually one party who has assets and one who doesn't. And the one who does will say, well, can't Joe just use
Yes.
my dad or a friend of the family? And we always say no for this reason, because if there is a dissolution of the marriage, you want the prenuptial agreement to stand. And you don't want there to be any arguments or claims that for whatever reason there was duress entering into the agreement, or that there was a lack of understanding on anyone's part. So not only do both sides need to have counsel, but both sides' counsel needs to sign the prenup agreement stating under oath that they've advised the client, they've gone through the prenuptial agreement with their client, and that to the best of their knowledge, the client understands the agreement. So it's absolutely imperative that both sides have counsel.
That seems like a very persnickety document, but I guess there's a good reason for that.
It is.
So, yeah, everybody goes into marriage with the intention of love, and this is going to last forever. But yes, we're lawyers, so we always have to think of, what if.
And I have to say, out of all the prenuptial agreements that I've drafted, maybe only 4 have ever actually come to be used. But I can tell you in those 4 cases, the parties were thrilled, or at least one half of the party was thrilled that they had the prenuptial agreement.
Well, we still have an understanding of what's going to happen.
And full disclosure.
Full
Full
disclosure.
disclosure, right.
So, yeah, so I guess, the other thing, I guess, if you hire an attorney and each side has an attorney, the attorney makes sure that there is full disclosure before the client signs it.
Absolutely.
You know all the potential inheritance, I guess, and things like that.
Absolutely.
So, wow, that's an important,
It
I'm
is.
sure a very important tool.
It absolutely is.
Wow. So you've mentioned some other documents here. What about the elderly? I mean, is there any particular estate planning for the elderly with respect to what nursing home to go to, and what if one spouse is in a nursing home? Is it just the healthcare proxy, or are there other estate planning things that come into play?
It is. That's a really, really highly specialized field. And if you want to talk about traps for the unwary, probably for the estate planner, that's where the most traps lie.
Wow.
And I would say that there's a lot of options that are available for folks. Now that there is legalization of marriage, now you can use documents like QPERTs where you're gifting property down the line to different family members in the hopes of getting the residence out of the name of the elder spouse, so to speak.
Sure.
There's also, there's now with annuities, you can purchase the annuities and you can name your surviving spouse as the recipient of the benefits. So there's different ways that you can work with those.
These are long-term financial
Planning,
aids.
correct.
And just so people know, an annuity is you pay money down and then you get a set income over years.
An income stream over a set of years, absolutely.
And the other thing you mentioned was gifting at different times?
Well, it's called a QPERT. Sometimes people use it because what you're able to do is where you have a family that's actually intact, then you can set up your marital home, let's say, and you can slowly gift it away to other family members so that it's not an asset of yours at the time of your death. The only thing with a QPERT is you need to survive. There's a term that's set by annuity tables, and you need to survive that term in order to complete the gift. But that would be another planning tool.
I assume that's for tax purposes
It is.
and Medicare, Medicaid,
Correct.
whatever.
Correct.
Wow. So many issues.
There's a lot. There's a lot of issues, and one that we've actually come across quite a bit is adoption.
Oh my goodness. Well, we're running out of time, so if you can very quickly tell us.
Sure. One of the things that we're obviously still recommending is that any couple, gay or lesbian, that has a child, you want to make sure that there's an actual adoption in place because just the names on the birth certificate do not automatically mean that a parental bond has been formed. So you just want to make sure that one party is formally adopting the child. If you're doing something like in vitro or whatnot, you want to make sure that the other party is a formal adoption. parent.
So good advice is to see an estate planner.
Absolutely.
Great. Thank you very much, Susan.
Thank you.
And thank you for tuning in on Legal Lines. Legal Lines is brought to you by the Massachusetts LGBTQ Bar Association. My name is Tim Lynch. I am your host of Legal Lines. It's brought to you live the third Wednesday of every month. Thank you again. Thank you, Susan.
Thank you.
Wow, so many issues. Even adoption comes.